Hello everyone, hope you're doing great. In the last recording or the last audiobook, we finished the part of citizenship and how to get citizenship, the Citizenship Act of 1955 and the acquisition of citizenship, in which we mentioned the five measures and the five measures by which you can get the citizenship of India. Now, in this recording, we'll be studying the laws of citizenship. Please take out your books and let's start reading. Laws of Citizenship. The Citizenship Act 1955 prescribes three ways of losing citizenship, whether acquired under the Act or prior to it under the Constitution, that is by renunciation, termination, and deprivation. By renunciation, any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. Upon the registration of that declaration, the person ceases to be a citizen of India. However, if such a declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. Further, when a person renounces his Indian citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, he may resume Indian citizenship. By termination, when an Indian citizen voluntarily, consciously, knowing and without duress or undue influence or compulsion acquires the citizenship of another country, his Indian citizenship automatically terminates. This provision, however, does not apply during a war in which India is engaged. By deprivation, it is a compulsory termination of Indian citizenship by the central government if a citizen has obtained the citizenship by fraud, the citizen has shown disloyalty to the Constitution of India, the citizen has unlawfully traded or communicated with the enemy during a war, the citizen has, within 5 years after registration or naturalization, been imprisoned in any country for 2 years, and the citizen has been ordinarily resident out of India for 7 years continuously. This was the laws of citizenship. Now let's move on to single citizenship. Single citizenship. Though the Indian Constitution is federal and envisages a dual polity, center and state, it provides only for a single citizenship, that is the Indian citizenship. The citizens of India owe allegiance only to the Union. There is no separate state citizenship. Other federal states like USA and Switzerland, on the other hand, adopted the system of dual citizenship. In USA, each person is not only a citizen of USA but also of a particular state to which he or she belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one set confirmed by the national government and the another by the state government. This system creates the problem of discrimination, that is, the state may discriminate in favor of its citizens in matters like right to vote, right to hold public offices, right to practice professions, and so on. The problem is avoided in the system of single citizenship prevalent in India. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and civil rights of citizenship all over the country, and no discrimination is made between them. However, this general rule of absence of discrimination is subject to some exceptions, that is, first, the Parliament, under Article 16, can prescribe residence within a state or union territory as a condition for certain employments or appointments in that state or union territory, or local authority or the other authority within that state or union territory. Accordingly, the Parliament enacted the Public Employment Requirement as a Residence Act in 1957 and thereby authorized the Government of India to prescribe residential qualification only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur, Tripura. As this act expired in 1974, there is no such provisions for any state except Andhra Pradesh and Telangana. The Constitution, under Article 15, prohibits discrimination against any citizen on grounds of religion, race, caste, sex, place of birth, and not on the ground of residence. This means that the state can provide special benefits or give preference to its residents in matters that do not come within the purview of the rights given by the Constitution to Indian citizens. For example, a state may offer concession for fees for education to its residents. Third, the freedom of movement and residence under Article 19 is subjected to the protection of interest of any scheduled tribe. In other words, the right of outsiders to enter, reside, and settle in tribal areas is restricted. Of course, this is done to protect the distinctive culture, language, custom, and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. In the case of Jammu and Kashmir, the state legislature is empowered to define the persons who are permanent residents of the state and confer any special rights and privileges in matters of employment under the state government, acquisition of immovable property in the state, settlement in the state, and scholarship and such other forms of aid provided by the state government. The Constitution of India, like that of Canada, has introduced the system of single citizenship and provided uniform rights, except in few cases, for the people of India to promote the feeling of fraternity and unity among them and to build an integrated Indian nation. Despite this, India has been witnessing the communal rights, class conflicts, caste wars, linguistic clashes, and ethnic disputes. Thus, the cherished goal of the founding fathers and the constitution makers to build an united and integrated Indian nation has not been fully realized. Let us understand the overseas citizenship of India.